Hello guys, let's get started. Today we're going to look at topic 1, which is the macro environment, which focuses on the impact of recent legislation on business. But before we dive into this topic, let's first recap on what you have done in grade 10 and grade 11 respectively about the different macro environmental factors that affect businesses. So these macro environments include external and uncontrollable factors that influence the business decision making and affect its performance. Remember, these are the factors that businesses do not have control over, and one way or another they affect how business operate. And it depends if they respond successfully to this factor, the business may perform with its steadiness in order to meet its objectives. So these factors include economic factors, demographic, legal, political, social conditions, and technological changes and natural forces. So you would see that some of these factors businesses can modify and make them favorable for their own business, but others they are not really controllable. So businesses have to just respond to them favorably. So the laws are very important part of business world as we know it, and the legal system is very complicated, and people who run businesses need to have a good understanding of it. That's why we're doing this chapter, the topic, which is the macro environment, the impact of recent legislation on business. You would see that it's solely focused on the legal side of the business. So the responsibility of compliance with any of the acts rests with the management alone, and the failure, unfortunately, to comply with this law can have serious consequences, such as criminal or financial penalties. It could also make members of close corporation or directors of the company personally liable for the business actions, and also it gives a business a bad reputation. Like it pollute its reputation, like the public image. People will have a very bad perspective about the business if it fails to comply with these laws. So we will further look at the burning questions that by the end of this section or topic, you'll be able to answer these major questions. So this chapter covers the effect of the following legislations on African businesses. These are Skills Development Act number 97 of 1998, the Labor Relations Act number 66 of 1995, Employment Equity Act number 55 of 1998, Basic Conditions of Employment Act number 75 of 1997, Broad-Based Black Economic Empowerment Act number 53 of 2003, National Credit Act number 34 of 2005, Consumer Protection Act number 68 of 2008. So these are the legislations that we're going to cover in this topic, so that you can be able to have a clear understanding of how they affect the business. But since I was telling you, let's first look at the burning questions that are very crucial to this topic. So the first question is, how does legislation affect the way business managers run their business? The second one is, whose responsibility is it to make sure that business complies with this legislation? And lastly, what are the implications for businesses if they do not comply with legislations? So these are the three fundamental questions that we must have in our mind while we go through this chapter together. Okay, so let's get started. So we're going to start with the Skills Development Act and the skills development levies that are corresponded. The Skills Development Act the Skills Development Levies Act was initiated in 1999 for a specific reason. So let's first look at it. So we're going to look at the purpose of the act. The purpose of the act is that this was the reason behind this was that South Africa was not fully equipped with the skills it needed for economic growth, social development, and sustainable employment growth. Remember, South Africa had some sort of a bad history, when we talk about apartheid era. You remember that there was a segregation. Most black people could not work because they don't have skills, and also they were segregated. There has certain rules that ensure that these people do not take part in the economic arena. So you will remember that if that was the case, then the country would not have skills necessary to move the country forward. So the National Skills Development Strategy aims to develop skills and learning capacity for employees. So within businesses, businesses were encouraged to have their training plans in order to increase the learning capacity of employees. And also, it makes it possible for employers to become more productive and competitive. The strategy is very simple. If you have a training plans in your businesses and you continually train your employees, then you become more skills and competitive out there to other businesses. And you become also productive, like your employees would work in a productive manner. And also it reversed the apartheid imbalances. Like I said, now we want to bridge the gap that exists between the whites and the black. So you remember that black people could not afford to have this opportunity to work. And also this is because they didn't have necessary skills in order to work as compared to white people. So it reversed that imbalance that took place in the past. And it also creates more inclusive and cohesive society. Remember, we're trying to bring people together regardless of the color of your skin. So the white, the blacks, Indians, colors, and others. Like, we're trying to bring these people together to mend the broken pieces that took place back then in the past. So let's move on to the application. How does it apply? What are the steps that the businesses have to take? So, employer must pay 1% of their workers' pay to the Skills Development Levy. The money goes to the Sector Education and Training Authority, which is called SETA. You will remember that this one was formed to just manage and monitor the training plans of that took place in businesses, and also the Skills Development Fund. So this is the funds are being sent to this Skill Development Fund in order to reserve them and release them whenever businesses wants to train their employees so that they can get them. So basically, the businesses are investing in training their employees, but they're investing to what? To SETA, to Skills Development Fund, right? It's simple as that. Okay, so now let's take a look at the Skills Development Levies Act, whether it applies to all employees, whether it applies to all employers or not. So you would see that these Skills Development Levies Act apply to all employers, but with an exception. So it doesn't apply to public service. It doesn't apply to religious or charity organization, the NGOs, so to say. It doesn't apply to other public entities that get more than 80% of their money from the parliament, because these are deemed to be government public entities. And It doesn't apply to employers whose total pay to its workers is less than 250,000 per year. Remember, this is a HR funding, the salary that is being given to workers. So it has to be 250,000 per year combined. So those employers who fall under this category doesn't have to worry about this act. And also, it doesn't apply to employers who do not have to register according to the Income Tax Act. So you will remember that if you do not have to register in the Income Tax Act, it means that you don't meet certain requirements, like your business doesn't have certain amount of revenue per year. So these are the employers whom have been exempted from this act, and they do not have to pay anything. Okay, so let's go on to the next act. The next act that we're going to talk about is the Labor Relations Act. The Labor Relations Act purpose thereof, you will remember that it took place in 1995 with an aim to promote economic development, social justice, labor peace, and democracy in the workplace. So basically now we look into the organization and try to bring this peace that we want, the social justice and the economic business. So basically is the outside in and the inside out. So when we talk about economic development, we must ensure that these companies do have an effect in the economic development of the country. So that is an inside out. And then social justice, what happens in the organization and outside the organizations after employees go out there. And the labor peace within the workplace, the democracy, it gives employees the voice to make decisions and stuff like that, to have their own organizing body within the business. So we're looking at that. So this is the nature and the purpose of it. So the Labor Relations Act applies to all employers, workers, trade unions, and employers' organizations, but it does not apply to members of the National Defence Force, National Intelligence Agency, South African Secret Service. So it doesn't apply to these members. So you must remember, these are the members who have direct contact with the government. So it doesn't apply to these members. They are not obligated to do that because this is regulated by the government. Okay. So let's go on to the next one. So now we're gonna look at various stages. I don't want to call them stages, but rather, let me say, we're going to look at some sort of rules. Like, you remember that for most businesses, the fact that Labor Relations Act subscribes rule on how to dismiss employees makes it very important. And however, the purpose of the act covers more than that. It promotes economic development, social justice, labor peace, and democratization of the workplace through freedom of association, organizational rights, bargaining and statutory councils, commission for conciliation, mediation, and arbitration, strikes and lockouts, workplace forums, and unfair dismissal. So these are the things that we're going to look at, including the labor court and the labor appeal court. I'm going to look at this later on because this one is very important. Okay. So let's first take a look at the freedom of association. So basically, freedom of association means the right to come together with other individuals and collectively express, promote, pursue, and defend the common interest. These include the right to join the union. So remember, employees may feel dissatisfied in the organization, so they would put their trust in the union in order to defend them. So they will come together and form some sort of an organization or join the union in order to defend themselves against the actions of the business that is not serving them well. So they do have those rights of freedom of association. Let's go on to the second point, which is organizational rights. So the Act allows trade unions to gain access to business premises and in order to recruit members and hold meetings. So basically, these are the rights that are given to trade unions in order to have an access to the organization and also its employees. So they basically recruit employees in that organization and ensure that these employees, they are served well in the organization. That's why you'd find that in most organizations there are various trade unions, others which hold the majority of members and others with minority members. So they have varying rights that it's accorded to them, but basically, they do have the rights to enter into the premises and recruit members and hold meetings. So let's go on to the third one, which is a bargaining and statutory councils. So bargaining councils are formed by registered trade unions and employers' organizations. So basically, these two parties come together to form bargaining councils. So they deal with the collective agreements in an attempt to solve labor disputes and make proposals on labor policies and laws. So as well, they may administer pension funds, sick pay, unemployment training scheme, and other such benefits for their members. So those are the bargaining councils that you will find within the organization, outside that they operate in the media of the organizations and trade unions. So let's go on to number 4, which is a commission for conciliation, mediation, and arbitration. So the Commission for Conciliation, Mediation, and Arbitration, which is commonly known as the CCMA, is a dispute resolution body established in terms of the Labor Relations Act 66 of 1995. So this is basically an independent body, and it does not belong to or is not controlled by any political party or trade union or any business. So basically, it actually represents, it either represent the business or represent the employees. It doesn't side whether it's siding with an employee or the business. It's very much neutral. So this is where all the disputes that took place in the organization are referred to. They are referred to CCMA. So it's a dispute resolution body. So those disputes that take place between the employer and the managers, of which the managers may be deemed to be the business as a whole, and these disputes are then referred to CCMA for conciliation and mediation and arbitration. So the Labor Relations Act makes provision for disputes that cannot be resolved in the workplace. So if this process fails to, if it fails, the dispute is then referred to a labor court. So basically, what happens here is that if CCMA fails to resolve the dispute that took place within the business, then that dispute is taken to the labor court. And then this is number 5, is the labor court and the labor appeal court. So basically what happens here is that the labor court has the same status as the high court. The labor court adjudicates matters resulting to labor disputes, and appeals are made to the labor appeal court. So basically, if the labor court fails again to deal with this dispute, the matter is therefore referred to Labor Appeal Court, where one member who is allegedly to be the one who has to prove that there is a dispute, then can appeal and refer this dispute to the Labor Appeal Court. Okay, so let's go on to number 6. Number 6 talks about the strikes and lockouts. So if the strike does not comply with the provisions of Labor Relations Act, the Labor Court can grant an order to restrain any person from participating in such action. So the Labor Court may also order payment to the employer for losses sustained as a result of illegal strike or lockdown. You have seen in various protests and strikes that protesters may vandalize or damage the infrastructure of the employer. So then there are certain provisions that are made when it comes to payments in order to compensate the employer's losses. Let's go on to the seventh one. So the seventh one is the workplace forum. This is where it gets interesting. So the workplace forum is not similar to the trade union. I will tell you why it's not the same. So the main aim of the workplace forum is to solve labor-related problems by establishing a cooperative relationship between all workers. So basically it's all workers, not only members of the trade unions or only employees who are not part of the trade unions. Basically this was all workers. Also non-trade union workers and the employer. So a workplace forum may be established in a business with more than 100 employees. Remember that. With more than 100 employees, thus then workplace forum can be established. Only registered trade unions may apply to the CCMA for the establishment of workplace forum, right? So I hope this one is quite understandable. Let's go on to the eighth one. The eighth one is unfair dismissal. Dismissal is unfair only if, and I will repeat this, only if the worker intended to or did not take part in or supported the strike or the protest. A worker refused to do the work of a striking or lockout co-workers unless this refusal will endanger life or health. It's unfair also if a worker is forced to accept the demand. It's unfair also if a worker intended to or did take action against the employer by let's say exercising the right or taking part in the proceedings. So that will be deemed unfair. It is also unfair if a worker is pregnant or intended to be pregnant. It's also unfair if an employer discriminated against the worker because of race, gender, sex, ethnicity, social origin, color, sexual orientation, age, disabilities, religion, conscience, belief, political opinion, culture, religion, marital status, family responsibility. So all of this, if an employer discriminates you against these grounds, then that will be deemed unfair dismissal. And lastly, it is unfair if the employer cannot prove, this is very crucial, if the employer cannot prove that a worker misconduct, if the employer cannot prove a worker's misconduct or inability. So if, let's say, the employer says that these employees had a misconduct and fails to prove such misconduct, then it will be deemed unfair. And also, if the employer cannot prove that the employer's operational needs are valid. And lastly, if the employer cannot prove that the dismissal procedure was fair. So the employer basically has to follow the procedure in order to dismiss employees fairly within the organization, right? So I hope you understand these concepts, all of them. So let us go on to the next part. The next part here is we'll talk about the Basic Conditions of Employment Act. So here basically we're dealing with the fair labor practices. So within this one, we're going to look at various issues that come into play within the workplace, such as working time, leave, sick leave, maternity leave, family responsibility leave. Basically, annual leave, sick leave, maternity leave, family responsibility leave, they fall under leave, like their package of the leave. So basically, we're gonna address them all together when we get there. And number 3 is the remuneration and deduction and notice of termination. So we're gonna discuss this all together. So let's start with the purpose. So here we know that the 1996 South African Constitution, the Section 23, gives every worker and employer the right to fair labor practice, and the Act applies to all workers and employers except members of National Defence Force, National Intelligence Agency, South African Secret Service, and unpaid volunteers working for charities. So remember, we also spoke about certain exemptions for members that are exempted from certain acts. So here it also applies. So basically, let's start with the working time. So an employer must not work more than 45 hours in any week. And also, a worker cannot work more than 45 hours in any week. Second, a worker must not work more than 9 hours a day if the worker works 5 days or less a week. Basically, if you work only during the weekdays, you don't have to work more than 9 hours a day. And lastly, a worker must not work more than 8 hours a day if a worker works more than 5 days a week. Right? So I hope that is clear and straight to the point. Let's go on to overtime. If overtime is needed, a worker must agree to do it, and they may not work for more than 3 hours overtime a day or 10 hours overtime a week. So it's very straight to the point. 3 hours overtime a day? No. 10 hours overtime a week? No. It has to be less than that. So overtime must be paid at 1.5 times the worker's normal pay, or by agreement, or get paid time off. So basically, it has to be over 1.5 times, unless if there is an agreement that took place between the employees and the employer. Let us go on to the leave. So we have an annual leave. A worker can take up to 21 continuous days annual leave, or by the agreement, 1 day for every 17 days worked, or 1 hour for every 17 hours worked. A leave must be taken not later than 6 months after the end of the leave cycle. An employer can only pay the worker instead of giving the leave if that worker leaves the job. So that is straightforward. Let us go on to the sick leave. This is the important one, because most people get this one misunderstood. So a worker can take up to 6 weeks paid sick leave. Remember, paid sick leave during a 36-month cycle. During the first 6 months, a worker can take 1 day's paid sick leave for every 26 days worked. An employer may want medical certificate before paying the worker who is sick for more than 2 days at a time, or more than twice in 8 weeks. So remember, a medical certificate is very crucial. You cannot get paid if you don't have that. Let's go on to the third one, maternity leave. A pregnant worker can take up to 4 continuous months of maternity leave. She can start a leave anytime from 4 weeks before the extended date of birth, or a date a doctor or a midwife says is necessary for her health, or that if her unborn or that of her unborn child. So she may not work for 6 weeks after a birth of her child unless declared to be fit for that job, right? At that specific condition. A pregnant or a breastfeeding worker is not allowed to perform work that is dangerous for her, like, and her health or her child. So that is straight to the point. Let us go to family responsibility leave. First-time workers employed later than 4 months can take 3 days paid family responsibility leave per year on request when the worker's child is born or sick, or for the death of the worker's spouse or life partner, parents, adoptive parents, grandparent, child, adopted child, or grandchild or sibling, right? So those are the conditions. It's under those circumstances that you can be granted family responsibility leave. An employer may want a proof, however, that this leave was needed. Okay, so let's go on to the remuneration deduction and notice of termination. So an employee must be let's say the employee must be paid according to the agreement. Remember that the agreement that is there stipulated in the contract with the employer, and deductions must be agreed by the worker in writing, right? In writing. So it's paper and pen. If the employer is required to do so by the law, the employer is required, basically it's law, it's required to do so by the law, to have a written contract stipulating remuneration deductions and the notice of termination. That is there on the contract. The first thing that you get when you get to the working environment, you are given a contract to sign, and you cannot sign that contract unless you familiarize yourself with what is written when it comes to remuneration deductions and the termination of that work. Okay, so let us now move on to compensation for occupational injuries and disease. So it's commonly known as COIDA. So basically what happens here is that let's first look at the purpose of the act. So the purpose of the act here is to improve the compensation for disablement caused by the occupational injuries or disease sustained or contracted by the employees in the course of their employment. Remember that. Underline that. In the course of their employment, or for death resulting from such injuries or diseases, and to provide a matter connected therewith, right? So if that happens outside your work, then this act doesn't apply. Okay, the act will not apply. Okay, so now businesses have the following responsibilities in terms of the Occupational Health and Safety Act of 1993. So a working environment must be made safe for workers. That is one rule. It must be, if you are the employer, you have to ensure that your working environment is safe, and there must be no risks to their safety. More especially those employees who work in a high-risk environment. So the environment has to have minimal risks of contracting either the disease or any danger that may result therewith. Second, workers must receive information, instructions, training, and supervision to ensure that the health and safety of these employees are guaranteed, like they are being adhered with. So this information is very crucial, and it has to be supplied by the employer. Okay, let's also look at the implications for businesses. So all businesses must register with their business, with the commissioner of the compensation fund. So each year the business must provide a commissioner with the information on the workers employed first, the wages paid to them, and lastly time they have worked. Okay, and lastly, these records must also be kept safely by the business for a period of 4 years, because they might be needed for review. Okay, so let's move on to the next act. Our next act is the Employment Equity Act. of 1998. We're going to look at the aim of the Act. Okay. So, the overall aim of the Employment Equity Act is to achieve equity in the workplace through the prevention of discrimination, which applies to all employers. Discrimination is not allowed in the workplace. It's not allowed at all. You have the right to voice out any action that you deem to have been resulting, either affect the either speaks to discrimination or unfavorable to a certain group of employees. The second one, the implementation of affirmative action. Affirmative action speaks to a certain group of individuals. So you will remember that in the past, there was an apartheid regime where blacks were segregated, and as such they couldn't get the same rights as compared to whites. So these people include the marginalized groups such as the blacks, of which is the colors, the disabled, females. So these groups are deemed to be marginalized groups, and they have to receive certain or special treatment. Some may argue that this is more like the reverse of discrimination, but it's actually not. Basically, here they're trying to balance the imbalanced. So now, the Act states that no person may unfairly discriminate directly or indirectly against the employees on one or more of the following grounds. Those grounds are the ones that we mentioned earlier: race, gender, sex, pregnancy, marital status. Those are the direct ground. But however, there are indirect ground. The situation where the employer discriminate. For example, I'm going to give you my personal example. So if the employer wants people who have cars, and we know that most black people do not have cars because they can't afford cars, and whites, of course, they can afford. So this is partially an indirect discrimination of for black employees. Now we're going to move on to Black Economic Empowerment Act of 2003 and the Broad-Based Black Economic Empowerment Act. So the nature and the purpose of this act is actually to seek to correct the disparities that were caused by the apartheid regime by promoting new opportunities and increase the level of participation for previously disadvantaged individuals and companies in the ownership and management, and also the control of the economy of the South Africa as a whole. So that is a broad-based black economic empowerment, is to enable black individuals, those who were disadvantaged in the past, to have an economic power to contribute to the economic development of the country because of what happened in the past. So that is the aim, the nature, and the purpose of it. Okay, so let us now look at the implications for businesses. So the BBEE compliance is measured in 7 key areas of the business, and it's very important that those businesses must comply and adhere to this act. So the first one here is the ownership. So with the ownership, there are given points where these points are earned by selling shares to black people. So the companies have to at least share some of the shares with disadvantaged individuals in order to have an access to the economic arena. The second one is management control. The points here are earned by appointing a black top managers and directors within the company. And then the third one is employment equity. These ones, the points are earned by employing junior, middle, and senior managers, and for the smaller business, black workers. So we try by all means to employ. It's similar to affirmative action. because it also promotes disadvantaged individuals, those so-called marginalized group. So it's similar to that one. With regards to skill development, the points here are earned by training employees through job training or formal training. So we have to equip these disadvantaged individuals in order to accelerate up the corporate ladder of the organization in order to contribute fruitfully in the organizational development and also ultimately economic development. Preferential procurement. So here the points are earned by purchasing goods and services from other businesses with a good BEE scorecard. We're going to discuss this later on in the section about the scorecard and the promotion of these BEE score cards. So it's basically purchasing goods and services from those businesses, so to actually improve the standard of those who are disadvantaged. The second last, the enterprise development. Here the points are earned by assisting smaller black-owned business to grow. So basically we have to support these emerging black entrepreneurs, these black businesses. They have to be supported in order to grow and compete with these bigger businesses. So remember, if we don't support these black small businesses, so they will always bid beyond their weight, so they won't be able to compete within the economic arena to their full capacity. So the last one is socio-economic development. Here the points are earned by supporting black social causes. So we have to support the black social causes. So I'm going to move on now to National Credit Act of 2005. Okay, National Credit Act. The aim here is to, let me first say that the National Credit Act has put into place the protection measures that aim to improve consumer rights as well as to protect and streamline the credit transactions. So we're gonna discuss that later on so that you can fully understand what we mean by that. But let's now first look at the implications. Okay, so the implications are that if we're looking at this act, all credits contract must be in a language and in a form which are easily understandable, and should be in that at least 2 languages, so that if you don't understand the one language, you can be able to understand the other. And all credit providers are obliged to do an analysis of a consumer profile to ensure that the provider can afford the credit applied for. Remember, this is not just to step on top of people. People must be able to afford what they are being provided with. The third one, one of the main purpose of the act is to prevent discrimination in the credit market and to ensure that the credit is available to all South African citizens. Okay. And this act also gives consumer whose application for credit was refused the right to a written reasons for that decision, for that refusal, So it gives them that specific right. And it also cool off the period of compulsory for all credit agreements. And also consumers under the Credit Act have the right to return the purchased goods at any given time during the contract to the provider to have for that good to be resold. And if needs be, they have to be given their money back. Okay, so Consumer Protection Act. So if we look at the Consumer Protection Act, you would see that the act here has been brought into law to promote and to advance the social and economic welfare of all consumers. So it's all about consumers. We look at the consumers and try to understand their rights, because they do have the rights. Because if you look at the businesses, yes, businesses do have the rights to conduct businesses, and also the purchasers, those whose services and product are being sold to, they also do have the rights. So we're going to look at that. If we look at the impact of the act on different aspects of the business, you would see that, for example, an example of the impact of the act may have a different aspect of doing business. So if we can take a look at this act, you would see that the act prohibits discriminatory marketing. That's the first thing. So it has to prohibit a discriminatory marketing. The second one, the act gives consumers the right to select suppliers, to be given estimates, the right to choose or examine the goods, and the right to return the goods, or so-called unwanted goods. Remember, if you purchase the good and then you feel that this good is maybe it has expired, or you don't see it as the goods that you wanted, you do have the right to return that goods to the shop and get your refund. So these are the rights that are afforded to consumers. Also, consumers are entitled to information in plain and understandable language. So remember, these goods must be written something. So the information that are written on the goods must be reliable, must be information that are creditable. The information to for those goods, how to use them, and how to actually, if they're supposed to recycle that, maybe if it's a bottle of cold drink, if the bottle has to be recycled, they must be able to be given that information so that they take a good care of that bottle. So various informations come into effect here to actually motivate consumers to purchase those goods. The Act also prohibits unacceptable conduct, false or misleading representation. So this is all about consumers. Remember, when it comes to marketing, consumers are the ones that we speak to. So this act speaks to consumers and how they react to the goods that are being sold and or services that are being rendered to these clients, whatsoever consumers. So we're talking about consumers. So consumers, when we talk about consumers, we're talking about those goods that are being sold to them, and the management between what the company is doing and what is happening out there to consumers. I'm going to give you a typical example. What if a consumer goes to a shop and purchase a goods? Let's say it's a meat or a bread, and then after that, that consumer eat or consume that product, and later on falls sick and transported to hospital, or for some reason, maybe let's say that consumer passed away. So what happens now when we analyze that goods that has been sold to that consumer? It is now the onus of the burden now it's on the business to prove that that good is good for the health of people, right? So these are some of the things that we need to look at when we're dealing with the Consumer Protection Act of 2009. So we're going to discuss some of the questions later on pertaining to only this section and see if we understand all these acts. These acts are very important because they lay a foundation into these business studies of yours. And you will understand it in the later chapters that it's very crucial for you to have this fundamental understanding of these acts and also their impact in the business arena. So for now, thank you very much, and I'm looking forward to speaking with you in the next section. Thank you very much.